And we are live.
Hey.
All right. Hey, y'all. Okay, so we're coming in hot today. We know. But forgive us.
We made it.
Just a little bit of grace. A little bit of grace. Um, excuse me. It's October and it's like decisively October. I don't even I don't even know what it means that it's October.
So the calendar says.
Yeah, yeah. So, how are you? Who
Who
are
are
you?
you? I know who I am. I am Alicia Holland, one half of the lawyer team at Dahlia Law Group. Who are you?
I'm the other half of Dahlia Law Group. And for those of you who have not joined us before, Dahlia Law Group is a law practice in Oakland, California, um, where we focus on the work of legacy. We do legacy and estate planning, probate, and litigation related to those areas because we see ourselves in the future. We see Black people in the future. We see queer people in the future. We see trans people in the future. Yes, we see people with different means, right? And different levels of access in the future, and every single one of us deserves to have a legacy there to meet us. So that's the who, and the why. The what for today is wills versus trusts. So we're going to be comparing wills and trusts today. We started talking a little bit about, well, we've had an entire series on the nitty gritty, sort of the 101 version of what is in a legacy and estate plan, one that's pretty basic and straightforward. What can it do? And as part of that, we've talked a bit about trusts specifically. So we went through a whole sort of subsection of the trust conversation, and we thought it only right to talk about wills as well. And so we introduced that conversation last week. This week, we are going to talk about some of the differences between wills and trusts. And so we will get to that. If that is why you are here, you are in the right place. But the way that we have this conversation every single week at 12:30 Pacific time on this channel is we first check in with the humans because in the end, that's who we're here about. So, how you doing, Holland?
I'm all right. I am here. I am was thinking about shortly before this as I was getting myself together and got lost on the clock. Uh, I think the concept is called the butterfly effect. And I know there was a movie. I don't really remember the movie, but I remember the movie is how I learned about this concept of just how all the things work together in seemingly ways that you don't even necessarily know. And so I was trying to figure out how to do a few things too many in a too short amount of time. And some things just magically peeled away and created space from somebody else doing something. And I was like, oh, yeah, I'm glad that I had a half a thought to take care of myself and do what I needed to do because the universe will take care of me. And so it just kind of magically created some space where I was trying to force a fit. So
Well,
I'm
good.
thinking about that right now.
Very good.
That's how I be. How are you?
Um, I'm all right. I'm all right. There is, there's, I don't know, like, there's a whole bunch of stuff going on. There's so many things. So many things. But I can tell you that one thing that I'm grateful for is to have the presence of mind at such a time as this, in these days, to remember to be present, right? There are some things that definitely need to improve. There are some things that need to get different um, right now. But I think that there is real value in the ways of the ways that I think I'm evolving personally, professionally, like all of those things. And so I find that all to be very exciting, and I am grateful for that. And some of it comes with some growing pains. So welcome to the human experience, right? So all is well. Tony is here. Hey, Tony, how you doing, girl? And I don't know, my sister might be joining us today, but she might not. I was. She had a birthday recently, and I was late in sending her birthday present. And that's not to say that just because I was late, she would not show up here. That's not how she is. But that's what we've been talking about, and we have not been talking about her coming for the live stream. So anyway,
We like birthdays.
we love birthdays. I love birthdays. I mean, I love anybody's birthday. My birthday is my favorite. That is true. But I will take a birthday. I think it's the coolest. And keep them coming, by the way.
That part.
That's my birthday
Yes.
policy. Just keep them coming.
Well, I just had to write somebody that scheduled an appointment with us next week, and it's a long appointment. And I happened to be putting stuff together and realized, wait a minute, this date looks familiar. This is this person's birthday. And I was like, hey, I don't like this. We take
Yeah.
birthdays serious around here. Can we talk? Can we change the things?
Yeah. Who needs to have a long appointment on their birthday? I mean, I
Right?
don't know. If that's how they celebrate, then okay, everybody gets to make those choices. But that's not what I would choose to be doing.
That part, what you said.
So, all right. So let's get into it, shall we?
I think we shall.
Excellent. So I went over a little bit of kind of the recap, right? We've been talking about the basics of planning. We've been talking about the personal authorization documents, and sort of that had, or those tools, and that had its own section of the conversation. Then we talked about trusts as sort of the primary um, asset director, right? Where the stuff goes, who gets to be in charge, and when, and the wherefores and whys and hows, and all of that stuff. We did a pretty deep dive on that with the trust as the boss. And then last week we started talking about legacy and estate planning, where the will is the boss. By the end of today's conversation, what I'm hoping folks will walk away with is an understanding of how wills differ from trusts in administration, because that information, it is my hope, will allow people to have a little bit more clarity about whether a will based plan is going to be better for them, or if a trust based plan makes more sense for them. And as far as spoiler alerts go, there's probably going to be some level of both. There might well be a bit of both. So do you want to kick off the dive into the specifics, and I'll get in where I fit in, or vice versa?
I can do it. I know
Okay.
things. So, the main difference between a will versus a trust, we talked about some of this at the very beginning before we got into the specifics conversation, but we wanted to come back here so that now that you have the context of what they do, to revisit those comparisons. And so one of the major differences that will pop back up of like, oh yes, I do remember them saying that, is whether a court has to get involved and how much the court has to get involved there. So on the will side of it, the court is the power giver in the document. So in the document that you're saying, when you create the will, you are saying the who gets the stuff and who gets to be the person to go to court and be in charge of submitting the paperwork. But the court is the one that's actually going to supervise that administrator for carrying out the duties that they have. So they're going to first, the court has to essentially bless the will to say, yes, this is a valid document that we can follow for what happens. If the court says, they missed it on a couple of things, this doesn't actually do it, then the court gets to say what is happening next as far as if they're still going to follow your instructions with court blessing, or if we're going to a whole new plan there. The court is also going to be the one to decide if the person that you selected to be in that role, so that role, as a reminder, is the person that we call, it's one that has a ///, what do they call it, a multi-hyphenate, or a triple threat, in that it gets named under 3 different names, but we use the term synonymously. So executor, administrator, personal representative. You're going to name one of those in your will as the person that you want to be in charge for overseeing what's happening. And the court is the one that is going to give the final say on if that person is fit to serve in that role at the time that it's time to administer your will.
Before we move on from there, I want to actually touch back to that first point that Alicia made. One of the very first things that a court has to decide is whether your will is a will, whether the piece of paper that it is written on is actually capable of giving anybody any power to do anything with anything that once belonged to you. So it is, it's really important to go back then with that in mind and to consider again those requirements for a valid will that we talked about in, I was going to say yesterday, but it wasn't yesterday. It was in our last,
it's one of the yesterdays.
Yeah, in our last episode. And so the beginning of this journey with a will, with any type of will, is it's a will, isn't it? Right? That's actually the starting question, and the court is the one who gets to answer it. Because if it is not, if the answer to that question is no, then the court actually has even more involvement, right, in the administration process. We have some other friends who have joined us. Shauna is here. Hey, Shauna. And my sister did come. Hey, Danielle.
Hey,
Danielle's here.
Oh,
Hi.
man.
What?
I'm bummed. My little happy birthday pic is in the plant outside. It's getting some sun. Because since Danielle had a birthday, I need the little happy birthday sign.
Well, she's here. You can just say happy birthday if you want to.
That too, but I like having props. Happy birthday, Danielle.
Okay. All right.
Why do a little when you can do a lot?
Mercy. Indeed. So the court is, you're going to notice a theme here. The court is going to be supervising all of the duties to administer the will. The court is going to be empowering all of the roles that are listed in that will. So the court is going to be involved all up and through. Okay, as it is said. So So pay attention to that. But thing one is that a will does not have any effect at all until it is accepted for administration. And a personal representative, or you might think of them as an executor or an administrator, they don't have any powers until those powers are actually conferred on them by the court, until the court gives them those powers.
Yes. And sometimes we can think, oh, well, that's not that big of a deal. I would rather the court supervise. But an important thing to know about that is not an instantaneous process. So there is a whole process, which we're going to talk about next week, called probate, what that court process looks like. But just know it might be a couple of months before or more before that person actually gets the power to do those things. And so in that space in between, that means no one really has any legal way to do the things that might need to happen immediately. So if somebody needs to access things to make sure that your family that you currently take care of, that can continue, that delay can be challenging. So that's an important thing to think about when we're talking about that. They don't have any power until the court gives it to them.
Right.
Then from there, thinking about the up and through of the court and like, well, what exactly is the court involved in? Is everything. So things like if we're going to sell a piece of property, that doesn't happen without court blessing. If we need to rent that property out so that it can continue generating income, that doesn't happen. If we want to give the things to the people, the distribution of those things, not without the court blessing. When we are going through and having to shift assets to get them the first job is that the court is going to oversee the process of that administrator, just getting everything in the same spot so we can deal with it. So think about the thought that's coming to mind right now is when you're cooking and you might be baking something, and step one is let's get all of our ingredients out where we can see them to make sure that we have enough of everything. And so that's going to be that administrator's first job is let me gather all of the things so that we can get it all visible and see what we're dealing with. The court is overseeing that process before anything hits that bowl where we're going to make this thing. The court is just going to oversee the gathering process. And then you have to give the presented plan of what do we want to do for the distribution, and the court is the one that's going to review that and say yes or no, or it needs to look different. So the court is involved in that entire process on the will side of things.
Yeah, and when we say the court is involved, what you should know is that the court is supervising. The court is not actually doing these jobs. The court is not actually... What you over there tearing up?
I dropped a pen. Sorry.
The court is not actually carrying out these tasks. Danielle says thank you. She says thank you, Alicia. The court is not actually carrying out these tasks, right? That is what the court will appoint the administrator to do. But what's happening is the administrator, the executor, the personal representative. We will call this role personal representative.
So we don't have to say all of them every time.
So that we're referring, so everybody knows what we're referring to. That's what the court appoints the personal representative for. What the personal representative is doing is essentially running off, performing the tasks, or making the reports or making the plans, and then coming back to court and saying, all right, this is what I'm thinking of doing. This is what the plan is. This is what I've already done. We good to go? And the court will say yes or no, right? And then the personal representative will run off, do some more work, and then they'll come back and say, this is where we are. Good to go? And this process can happen in as few as a couple of hearings or as many as very many hearings, depending on what actually needs to happen. What the will requires, what the law requires, so on. So it is a dance of coordination between the supervisor, which is the court, and the personal representative, who are who are sort of going back and forth to make sure that the terms of the will are carried out and the requirements of the law are carried out. And as a practical matter, let me just give you a practical sense of what would happen if we filed a probate petition to start a probate process. Actually, we did just file one. The hearing date, the earliest hearing date that we could get for the first hearing, just for the court to say, yeah, this is a will. Okay, we'll accept the will for probate and actually start empowering people to do things, is more than 2 months away. So we're talking about around Christmas time. But then the court's going to close between Christmas and New Year's. So then we're talking about in the new year. Then the next set of hearings probably won't happen for another 3 months. Then the next set of hearings probably won't happen. And I don't mean that to discourage anyone from going through the probate process, because I actually think that probate gets a bad rep. And there are some really critical benefits that can be had by going through the probate process, or at least some portion of it. But as a practical matter, I don't want what we run into quite a lot is people will come to us and say, oh, well, how long should this take? Right? The personal representative is saying, okay, well, I told my family that we should have this wrapped up in a couple of months. That should be fine, right? And the answer is absolutely not. And so people get they can get a little upset about how long it all takes. People, listen, some of y'all fall in my camp. You think a couple of dollars is coming your way, and you already spent that money in your head. You're already like, oh, I know what new sewing machine I'm about to get, or what new motorcycle I'm about to get. Don't judge me. Or whatever it is, right? And the idea of how much time it should take and how much time it will take don't always match up. Probate can be quite a lengthy process, almost as long as it took me to explain how lengthy it could be.
Yeah. And well, I think another important point on that is the part where people can get really confused and frustrated by that is when they're like, this probate process is if there is a will, but we're also in this same process with this same timing if a person dies with no will and no trust.
That can take even longer.
So the court
can
has
take
to determine
well longer.
who are the heirs.
Mm-hmm.
And so the point being that when there is a will, there's a paper that says, I want this thing to go to that person, so give this to them. And so we're in this complete time delay when it's like, well, why can't we just do what the paper say? And it's like, we are just doing what the paper say, but there are these 87 steps between the paper and the actual execution of it. And that can be really hard to comprehend when you're the person at the end of the list. And it's like, but I can see it. It's right there. Why can't you just hand it to me?
Right. And so the process itself has timeline requirements that are legal or constitutional requirements. But then also, not to put too fine a point on it, but if this is my will that's being administered, it's fair for you to believe that maybe I'm not the only person who died in the county where this court has jurisdiction. So there are other people whose wills are being administered as well, and they have to go through this same process with the same one or two judges, right? And so it can just take a while. It can take a while. That's not necessarily a bad thing. It's just by way of setting expectations.
Yeah. So one of the other things that the court is going to supervise by way of this process, as one of the 87 steps in there, is supervising the payments to creditors and creditors' claims as well. So one of the deals is we don't get to give everything away before we have paid the bills. You got to pay the bill. And so one of the parts of that process is certain people need to be notified that the court has been engaged to complete this process of administering this will. So there's going to be something published in the newspaper. Then there are going to be certain people that you know about that are creditors, potential creditors, might be creditors, and those people also need to be notified that the court is administering the will. Now, the good news about that process is that it does create a very finite period of time where we get to have a speak now or forever hold your peace deadline. So that can be one of the fortunate benefits of probate. But what that means is the court is going to oversee that process. So, and I think something that just made me pop into my mind as we're talking about the court involvement, something that I think you said, Jill, that I think is really important to highlight is, while the instinct is like, great, let me let the court do this job. That'd be wonderful because I know they're going to get it right. The court is not doing the work.
Mm-mm.
When we say the court is involved in the process, the court doesn't even fill out the final orders. They expect you to fill that out and check the boxes and send it to them. So all they have to do is put the stamp on
Listen,
it.
Petty Betty, I heard that. I heard it. Carry on. No, carry on with your cute little background and everything. I see you moved around into the creative space today. Go ahead, Petty Betty.
Well, I was playing with the Skype backgrounds, but I decided I wouldn't do that. So.
Yours is better. Your background is better.
It's true. So that's how I mean when the court supervising these things is it's just you have to submit it to the court for blessing on all of these things, but the court will not be doing the work.
Right.
And so that creditor involvement is another place where it's, okay, we have sent the notices and this is what we got back. These are the bills. This is the proposal for how we want to pay these bills, or we've negotiated the bills and this person is willing to take this much left for how to distribute those things to pay the bills. The court is going to want to see that first before we get to giving the things away to the people.
Mm-hmm.
So that's another place where there's going to be some court involvement.
Yeah, absolutely. And one of the cool things, one of the benefits of this process for the bills being accepted or paid or negotiated or whatever, we call them creditors' claims. One of the benefits of this is that finality that Alicia was talking about. This process of having creditors' claims decided, and what we mean by creditors' claims, I put it in the discussion box there, is that creditors' claims are just where people or businesses get to make claims for money that they believe that the person who died owed them. And so if I die owing a bill to somebody, then that person doesn't necessarily have to write off the bill just because I've passed away. They can have that bill collected from my estate, right? If there's money in my estate to pay them, right? Because dying is kind of like the ultimate bankruptcy. Whatever's not there, right? It's just not there. But these creditors' claims, going through the court process for this really creates this sort of speak now or forever hold your peace kind of moment about them, right? So everybody knows that the court is administering the will, notices will go out, all of that. People will have an opportunity to say, hey, Jill died owing me money. I would like to be paid. And by the way, pay me first, right? Before you run out of money.
Here is my bill.
But if Alicia later comes back and says, oh, Jill died owing me money too, but it's all been decided, then a court is not going to undo, the administration of the will, just so that some person who came along late with their bill saying, hey, pay me as well, so that they can have that bill paid. And so I'm saying this because this ties back to the time that it can take for a will to be administered, and we'll talk about all of that more specifically when we talk about the probate process. But part of the reason that it takes the length of time that it takes is because the law wants to allow time for everybody to get the notices that they're entitled to get to, so that when you do get that final order, that it is final and you don't have to worry about coming back and having to do any part of this again.
Yes. Then shifting gears, or actually before shifting gears, that final order piece that you just mentioned, that is another place of court involvement where they're going to give the blessing to finally administer and close the estate. And that final one is going to be, okay, now we have looked at all the papers, we know where all the stuff is, all the bills, give the things to the people, go ahead and do that.
Mm-hmm.
Then your personal representative can do that, and then we'll have to come back to court again to say, I've done it. Can I be out of this job? Please fire me now. And so then the court is going to bless that to officially close the estate. So the court is going to be involved a long time, and that also means in the pocket of your estate for a long time, because these things come with charges when we have these 87 steps along the way.
Right. So one of the other things that, we've kind of talked a bit about the some of the pinpoint specifics that the court might be involved with or might have to have responsibility for in administering a will. And I know that we told you at the beginning of this episode that we would be comparing wills and trusts, and the reason for that, sort of the pre-work leading up to the specific will versus trust conversation, is because that is one of the critical differences, right? Mm-hmm. When we say, one of the differences between a will and a trust is the amount of court involvement. It doesn't really feel responsible to just leave you with that and not have some specific insights about what is the court actually involved with, and what is it doing and why, right? Like what practical impact does that have on administering or wrapping up someone's final affairs after death. So, excuse me. So that's part of the reason that we went through that, and now we're going to actually shift gears into the direct comparison, because one of our goals, of course, is for you to leave being able to really think about what you know about a trust now, think about what you know about a will now, and then to kind of start making some of that comparison for yourself to see what might make sense for your own planning. So you probably picked up by now that both wills and trusts can dispose of assets. Right? Both of them can dispose of money, of personal property, right? Like things that you can touch, real estate, business interests, and that sort of thing, right? Here's a difference. A will can only dispose of assets. Actually, a will can only do anything at all, really, when somebody has died. A trust can do that whether somebody is alive or dead, right? That is a critical comparison difference between a will and a trust. A trust functions whether I am alive or not. I can empower somebody to handle my affairs while I am alive. I can also direct that same somebody or a whole different set of somebodies to handle my affairs under the trust when I have passed away. Will, not so much. Will is only going, a court's only going to bless that will. The first thing they're going to ask is, when did the person die? And if the person is still alive, they're going to tell you come back another time.
Yeah.
Yeah.
That is true.
Both a will and a trust require someone to be willing to take on that fiduciary duty that we talked about when we were talking about the role of the trustee. And I keep wanting to say yesterday and last week when we were talking about the role of the personal representative. Remember, that role has a fiduciary duty. It is the highest duty under the law to administer either the trust or the will, as the case may be. So somebody needs to be, the person who is standing in that role needs to be willing to do it, but they also need to be qualified to do it, right? Like they need to have whatever level of skill is necessary or whatever level of support, right? Because I have plenty of things that I'm responsible for doing that I don't have the skill to do. So I have the support to make sure that, that I can get those things done. They have to either have the necessary amount of skill or the necessary support in order to carry out that fiduciary duty. A critical difference between the will and the trust on this point is that the trustee is effective in their role. The trustee's powers are effective when the trustor, the grantor, the person who is making the trust, says that those powers are effective. Bam. I said what I said, right? Because I said so, right? A personal representative who also has those fiduciary duties that we talked about, those powers are not effective until a court says so. Okay, so that's a critical difference between those two things. But here's the rub. Even though a personal representative does not have any powers until a court says so, they can have responsibility even if a court has not blessed them in the role yet. So, for example,
What you talking about, Willis?
here's how it could look. If I am the personal representative under Alicia's will, and Alicia has passed away, and I know that Alicia said, give my vintage stove to my goddaughter, right? I know that. Then I go ahead before a court has blessed anything, and I give that stove to Alicia's goddaughter. Even though I don't have the power yet to do that, I am responsible for having done that. So if it comes to pass that Alicia died with a bunch of bills and we actually needed to sell that stove in order to pay for the responsibilities that Alicia passed away owing, then I got a little bit of a problem because I am responsible for having given away that asset when I did not have the power yet to do that. Does that make sense?
Yup.
Yeah. I heard you say what you're talking about, Willis. That's what I was talking about.
Yeah. Because everybody going to be looking at you like, why you do that and go get it?
Or do something to make it right.
Or go in your pocket to replace the value of that thing because nobody told you to do that.
Mm-hmm. So it is possible to breach a fiduciary duty even though I don't have the power yet. I don't even have the power of the role yet, but I can still breach the duty. Ain't that something? The takeaway there,
Yes.
yeah, the takeaway there is to do what you are empowered to do. If you're in that role, do what you are empowered to do, and make sure that you actually have the power that goes along with the responsibility, so that you're always operating in your lane. Yeah,
Yes.
I don't know. Should we have an episode about, like, what do I do if I'm the trustee, right? Like, what are some practical tips for trustees and administrators or agents, folks who have this fiduciary duty?
Yes, it's coming soon.
Oh, we already talked about this. Well, there you go, y'all. There you go. Okay,
So
I
stay tuned.
right. Okay, so I know that I just talked about a lot of information. I want to recap some of that in the comments while Alicia picks it up from here.
Yeah. So we're talking now about the comparison. So we talked about both of these documents, will versus trust, can help you can say who you want to get the things to. And both of them allow you to designate a person that can take on the fiduciary duty of carrying it out. So you need to have a person that's willing to take that duty on. So then when we're thinking about, well, how do I compare the two, in like, we talked all that stuff about the 87 steps, but give me some concrete bullet points for how I make this comparison so I can kind of figure out what columns do I want on my this versus that checklist. And so the bullet points that are a good idea to use are to think about court involvement, because we're thinking about how much court involvement there's going to be in will versus trust. Time, so how long is it going to take to administer this thing? Money, how much is it going to cost to administer this thing? Privacy, how much information is going to be out there about if I administer this thing? Creditor management, because we talked about bills always get paid before we have fund money. And lastly, dispute management. If my people are contentious and like to fight just for the sake of fighting, how does that get managed? Because when we think about those categories, that's going to help us with kind of narrowing down what feels like a better fit based on a situation. So the court involvement piece of it, we talked about that court involvement in detail on the will side of it. And so, kind of what we said on the will side, the paper does not get any power to do the things without court involvement and court blessing. Versus on the trust side, because you've already said when your trustee who has that fiduciary duty, when their job is triggered to begin, that's part of what happens in the trust, is because it is a contract. You've already said under the terms of the contract when their role becomes effective. And so that can happen without them having to go to court to get that done. So then from there, we think about the time side of it. So we talked about the time on the will side, where you've got the time before they even get the power to do the thing and for the court to actually say, yes, this is actually a will, so let's go with the terms of it. Then there's also the time that's involved of each of those intermediary steps where court says, go do the next thing, check back with me when you're at a position to review it again, and the back and forth. So there's some time involved there. So on the short end, a quick clean probate that goes really smoothly, talking about 12 to 15 months if everything clicks right. But then there are all the ones that something doesn't click right or something was missing, and so now we have to do some extra back and forth, so it can take longer than that. So that's the short end range. On the trust side of things, on the time side of it, because we've said on the paper exactly when that person's role kicks in, that means they can immediately get to work with carrying out the instructions, whether that be distribute the things, start this account, give this to this person, sell the property. They can immediately get to work on it, and they have the power to do it. So thinking about in particular things like selling the property, whereas we said on the will side, we have to go to court to get permission to do that. And some of that court involvement in the permission can be that we have to put the property on the market, get an offer, and then take that offer back to the court to get that approved to even complete that accept that offer and complete that transaction. Or if it's going to be, I happened to see this recently and it was very cool.
I was going to say, Alicia's telling y'all about her past 2 weeks. That's what she's talking about.
Which is that in a probate sale, it can be an auction, and that auction actually happens in the courtroom. And so it's a matter of giving notice, having the people that want to purchase the property show up for that specific hearing date, and the court is involved in that way. On the trust side, you just put the property on the market, sign the paper, and it's done. And it happens that way.
Yeah.
So then you look like you were going to say something. Nope.
No, I didn't want us to get too far into the weeds of the process, like into the granular specifics of the process, especially since we'll be talking about probate next week. But that's not what you were doing, so I don't have anything to say.
Okay.
I'm just managing the comments.
I appreciate that. So then
Well, you always appreciate it when I shut up. Go ahead.
I've been appreciating managing the comments and chatting with the people. Oh, so misunderstood.
But so
if
it is.
People understand me. That's the good point. So on the money side of it, and will money versus trust money, so we talked about on the will side, the money involved is there are going to be some costs that are involved. So the court does not just see people and oversee these things for free. So there are going to be some cost to the court, filing fees that the court is going to require. There are also going to be some fees when we talked about some of those notices that have to happen. So one, for instance, is that things have to be filed in the newspaper. It's called proof of publication. And so the newspaper is going to charge a fee to do that. Then when we do that ingredient gathering process that we talked about of gathering all of the assets to see what we're dealing with, for certain ones, the court may require some involvement of a professional to put a value on it. So that's going to have a fee. And then if you have a lawyer representing the estate to make sure that all of these steps are happening correctly, then that also comes with a fee. So those are some of the money things that we're dealing with on the will side. On the trust side, the trustee, there is still some money that can be involved on the administration, but you can knock off the court involvement part of it because we're not running back and forth to the court, so we don't have that money involved on the trust side. What we do have money-wise on the trust side is that the trustee, for being in that role, is generally entitled to reasonable compensation because no one should have to work for free, and so it may take some work. So they may be paid for that role. And they might decide to hire an attorney to help them with carrying out those instructions, but because all of these things can happen rather immediately, that's likely to be a much lesser fee than what we're dealing with on the will side with the court involvement. Then moving to the privacy portion of it. So on the privacy part of it, one of the things that happens on the will side when we file this with the court is those court filings are a matter of public record. And so that means anybody can see that the case has been filed, that it's going to be administered. We've also talked about it's going to be published in the newspaper, so that information is going to be there. Then while they can't, and it, depending on where you live, certain parts of the documents, anybody with a computer and an internet connection may be able to see some of those documents just going in there. But even if that's not the case, what they can do is actually go down to the courthouse and request to see the file, and then they would be able to see all the filings that are involved in this probate petition, including what the will says, who's getting what. And so they start, people, vendors can buy these things even, and we'll start sending solicitations to those folks. So that is to kind of highlight the publicness of that process on the will side of it. Contrast on the trust side of it, because we have minimal, if any, court involvement, all of that administration can happen privately. So the only folks that are entitled to notice on the trust side of it, that trustee is in the role and is now going through the process of administering it, are people that actually have some business within that trust. So it's going to be the people who are actually getting something, or people who are potential would-be beneficiaries that aren't necessarily named in the document to know that this is being administered. That's it. We're not publishing it in the newspaper. There are no public filings that anybody can go and request a file to. It is the trustee only has to mail it to that very finite list of people that this trust administration is happening. Then next up we have the creditor management was our next bullet. And so on that creditor management, we talked about on the trust side, or excuse me, on the will side, where the court is going to be involved in that process with the notices, the speak now and forever hold your peace part of it. And there is some of that on the trust side in comparison to where we have to give notice to certain creditors and pay those bills, but the timelines are very different. So California, for example, on the will side, we're talking about a 4-month time period, whereas on the trust side, we're talking about 180 days is what we're dealing with on that notice period.
That's
And
just
so,
for that's not just for creditors though. That's not, I mean, if somebody has beef about a will, then I mean about a trust, then that 180 days. But creditors, are creditors the same?
so with that, what you can have is on the trust side, because if a creditor is potentially named in the trust specifically, then they would be subject to that same 180 days. But what it also means is if I have the list on the trust side, I have gotten all the creditors, the bills, I know what I'm dealing with, and I get that done in 30 days, then I can start paying those bills and keep it pushing. Whereas on the trust side of it, I'm still subject to waiting that amount of time and submitting my list back to the court for how I want to handle this. And we can't do that until that time frame has elapsed. So we can do that much faster, potentially do it faster on the trust side of things.
Gotcha.
Then last bullet point that we had is the dispute management piece of it. And so, like we said, sometimes people like to fight just for the sake of fighting. And so on the will side of it, the court's already involved and is in it. And so at every step in the process, since we have to give notice to certain folks, and if they have some fight or objection about that particular thing that's being noticed, then we already have a date set for when they need to bring their beef in. So if we have particularly contentious people, then that might be a thing that to consider of, let's just get the referee involved, the referee meaning the court here, involved from the get-go, so that at every point we know somebody was reviewing this thing. Flip side, on the trust, for dispute management, what happens is the trustee sends the notice and they have to do particular accountings and send things that are, this is what I have done. They don't necessarily have to send a proposal of this is what my plan is. And then once that beneficiary gets it, if they don't, if they feel that something was done improperly or that something is not as transparent as what they believe it should be, they do still have some avenue for going to try to work out that dispute, but it might be after that action is done. And so then it's asking the trustee to justify why you did this instead of being able to step in before the thing happens. And so that is on the beneficiary at that point to then go seek out court intervention and involvement to figure out if that was a thing that was proper or what needs to happen to fix it there. And so that can take some time, but you can see where it's an after the fact court involvement on the trust side, whereas on the will side, it's before it ever happened. You have to tell me that this is the plan, and if I see it and see something looks amiss, then I can step into the court and say, hey, I want to flag this, so the court can have that information before they bless that transaction. So those are the kind of the comparison points that we're thinking about in trying to decide which is the right fit. So with that, we talked about this word court involvement in probate. And so next week, we're going to actually get into the more specifics of it with kind of more of an actual checklisting, like timeline of what that process is involved. So you can see, like, okay, now you keep saying 87 steps. Is that just a figure of speech? Is it really 87? Is it 811? Or is it only 12? And so we'll talk about that. But the homework that you have for thinking about that is actually, now that you have that context and thinking about that timing, the kind of those comparison points of thinking about, for me, for my assets, for my people, which ones of these actually rise to the highest level of concern for me? Because even with, for instance, the time, the money, the privacy, if you know that you have some highly contentious people, then having that dispute management piece might be the thing that is the highest priority to you, which helps you deciding on which side to go on. So think about those differences between the will versus the trust for what fits your situation. Then, if it's a will, you can start identifying people for the jobs that you want them to have. Who do you want to talk to about if they're willing to take on that fiduciary duty? The good news is, for the people that you want to give stuff to, you don't have to talk to them about that. But you should be thinking about what things you want to assign to which people in the document, because that's going to be part of what you're going to be gifting. If it's on the trust side that you're thinking about it, similar setup, who do you want to be in that fiduciary duty, and speak to them about their willingness to do that, so that you can start identifying the people for the drafting. And then same thing, who gets what and when do you want them to get that, and start thinking about that so that you can document that. Then the last piece of homework is one that you've had for a few weeks, but you can kind of gather, like, we're trying to put a lot of stuff in the paper, and so that's why this is a homework assignment that's not, it's not designed to be overwhelming, because sometimes in overwhelm we go flamingo and do nothing, and we absolutely don't want that. So continue working on gathering up the information about all of the things that we've been talking about, all of the various assets and documentation that might become things that you're distributing to people. Start gathering those things up. Also, whatever bills and creditors that you have, whatever documentation you have for that, gathering that up so that it will be available to help the people that you've got in those fiduciary roles to be in good position to actually carry out that job for you as quickly and efficiently as possible.
Yep. So I am just dropping some of these summary points in the chat box. But of course, as always, your questions are welcome here. We solicit them. So if you have questions, please mark them down for us, and we're happy to answer them with whatever we know. And if we don't know, then we'll tell you that, and we're likely to go find out and come back and answer when we do. In the meantime, while you are sort of putting together your final questions, know that if you don't think of questions today, as always, you can reach us on all the channels. You can reach us on Instagram at Dahlia Law Group. You can reach us on the web at DahliaLawGroup.com. You can you can reach us by phone. You can reach us by email. All of our contact information is just a Google away. And we welcome your contact. So please feel free to reach out to us. We are here every single Wednesday at 12:30 p.m. Pacific Standard Time, and we appreciate you spending your lunch hour with us and going through this information. If it is useful to you, please pass it on to somebody else. If it is not useful to you, please pass that information on to us so that we can do whatever is in our power to make it useful. Danielle says that we should do a show on politics. And
We got plenty of thoughts.
Well, we also did just last week a voter education presentation on the California ballot measures for 2020. We did that, and we have the slide deck for that presentation. If it would be useful for us to post that up on the website or put it somewhere, we are happy to do that. Let us know, for those of you who are affected by that, or who could be helped by that. If you're in California, let us know. We went over all of the state measures, and we also included the measures for Alameda County, which is where we are, and Contra Costa County, because that was requested of us. So yeah. Well, listen, thanks you all. It looks like we don't have any live questions. Thanks, Lisa. Thank you, Shauna. Thank you, Tony. Thank you, Danielle. Thank you all for being here. And Lisa is saying, yes, we should do a session on the ballot measures. But Lisa, you're not in California, friend.
But I get Danielle and Lisa's point of maybe a session not necessarily about our state specific ballot measures, since not everybody's California, but how to read a ballot, like how to read them and go about being an informed voter. So
like the thing that we would typically do at the beginning of the live voter education session.
Yeah,
so
got it. To how we said, like, how to find a lawyer. Like, I got all, like, how do I decide? Like, what criteria should I use in my picking?
Okay, I'm happy to do that. If we're going to do that, we should do it soon, because
I want you to VOTE.
Yes. Okay, Lisa said, I don't live in California, but I'm interested. So, okay.
We'll send you the slide deck, Lisa.
All right. Thank you all. Have a wonderful rest of your week. And we will, if we don't talk to you before then, we will talk to you next week at 12:30 right here. All right. Bye.
Bye.